Major breaking news. We have a huge legal brief that's been filed by several parties, including Defense Distributed and Polymer 80, in the Vanderstok quote-unquote ghost gun case pending before the United States Supreme Court. This is an attempt, as you know, by the ATF to expand the definition of firearms to include parts of frames, parts of receivers, and weapon parts kits that exclude the essence of a firearm, frames and receivers. Let's talk about this major brief submitted by major parties in the U.S. Supreme Court when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Terrorist Attacks on Israel Teach Americans About the Right to Bear Arms. If you already own a copy, feel free to leave a review on Amazon. Check it out. As you know, we must always learn the lessons of mistakes that other people make so we can learn from them. Just like we're learning right now about the mistakes the British made by giving up their right to free speech. Okay, folks, major deal here. Major brief submitted by some of the plaintiffs in the Vanderstok case, including the companies of Defense Distributed and Polymer 80, and the nonprofit organization that we're all familiar with, the Second Amendment Foundation. They filed a brief in the U.S. Supreme Court with some major attorneys, Chad Flores, Josh Blackman, and Adam Kraut. And essentially this argument, or the set of arguments they're making here in this brief, is very compelling. I would say overall, the gestalt of their argument is essentially to say that if you look at what the ATF is trying to do here, they are essentially creating a whole host of vagueness and ambiguities and issues that ordinary Americans, whether they be private citizens or companies, are simply not going to be in a position to know whether or not they're complying with the law or not. And one of the key points this brief makes against the ATF's attempts to redefine firearm, and as a reminder, as you know from prior videos, the Vanderstok case pending before the Supreme Court is all about the ATF changing its definition of firearm, specifically changing what a frame or a receiver is in the year of our Lord 2022. Because from the year of our Lord 1968, when the Gun Control Act of 1968 was adopted, through 2022, the ATF defined what is a firearm, and specifically what is a frame or receiver of a firearm, in one way and one way only. Then, in 2022, the ATF decided to expand the definition of what is a frame or receiver to include essentially things that have the potential to become frames or receivers. And as we've talked about in other videos, if something is like a Rembrandt painting, it's not a Rembrandt. If something is like a Picasso painting, it's not a Picasso painting. So too, if something is similar to or like a frame or receiver, well, it's not a frame or receiver as I see it. Now, with that said, this powerful brief submitted by Defense Distributed, the Second Amendment Foundation, and Polymer 80 basically is saying that the ATF is purposefully, if you will, trying to create ambiguities in the law, which has the effect of what's known as a chilling effect, which means that people that want to be able to make their own firearms in compliance with the law are never really going to know for sure if they're capable of doing it, because the lines between what is lawful and what is criminal is fuzzy and unclear. And that is not a bug by the ATF as I see it. That is a feature, because this administration, the Biden-Kamala Harris administration, which oversees this Department of Justice and this ATF, is all about chilling and deterring, if you will, people engaged in gun culture, the self-defense private gun culture that we've known since before we were even a country, including making your own firearms. This chilling effect or deterrent effect, trying to discourage Americans from learning about firearms and making their own firearms, is what this administration wants. They do not want us to be self-reliant. They want us to be entirely dependent upon the government, not just when it comes to our self-defense and protection, but obviously the ability to acquire arms if we need them for self-defense. And again, this brief, as I see it, if I can sum it up and characterize it, is basically saying it's totally improper for Americans that want to make their own firearms to have to go, "Mother, may I?" to the government and say, "Tell me whether or not what I'd like to do is lawful or not." And then basically, because the ATF's like, "Oh yeah, if you have a question about lines, can you do it? Can you not do it? If something's a frame or receiver as we see it, just let us know, ask the question." Oh yeah, first of all, we don't want to talk to the government about any of this stuff because we don't trust the government. How can you trust the government? I mean, the number of things that have been hacked and leaked and so on, it's insane. Their behavior is not trustworthy. There's no evidence that government is trustworthy ever in history, not just in the United States, but anywhere else. And that's why the Founding Fathers designed the Constitution to deter and discourage bad governmental behavior, because there's such a long history of it. So the notion that you could go to the government and say, "Hey, Mother, may I make my own gun? Is this a frame or receiver? Is this a firearm? Am I going to go to prison or not?" is absurd, because we don't want to be doing that. And even if you go them, as we saw in the bump stocks, even though they said, for example, "Hey, yeah, bump stocks are perfectly fine. Those are not machine guns." Then like 3 years later, guess what happens? They say, "Oh yeah, bump stock is a machine gun." So even if they tell you one thing, you can't even trust what they say. So again, I think this brief does a great job explaining that the ambiguity and vagueness associated with their redefinition of what a firearm is, specifically what a frame or receiver is very important, because as we've talked about in prior videos, up until 2022, you were able to sort of objectively know if what you had in your grubby little hands, let's say, was a frame or receiver, was by literally looking at it and saying, "Okay, what am I holding right now, and what work has been done up to this point in time?" But what the ATF has done is they've now made it vastly, vaguely open-ended and unclear as to what a frame or receiver is, because now rather than looking at what you've got in your hands and saying, what do I have in my hands and what's happened up to this moment in time, the ATF has now created this non-exclusive list of 8 factors, including items that have nothing to do with the actual frame or receiver, like instruction manuals, jigs, and other sort of things like that. And they basically say that now we're going to ask, what is the potential that what you're holding could become a frame or receiver? We talked about in a prior video, think about looking at an 8-year-old boy on a playground. You would look at that 8-year-old boy and he has the potential to be Tom Brady. He has the potential to be Olympic gold medalist. He has the potential to be a Supreme Court law clerk. He has this potential to be a judge. But that doesn't make him any of those 4 things, for example. But here, the ATF in 2022 decided that they want to look at what you've got and ask, what can this potentially become if you do some additional manipulation, if you do some additional screwing, some changes, some fabrication, some drilling, some milling, whatever it is? That's the question they're asking. So they've now made it entirely open-ended and vague. And this brief does a great job explaining that this is not only is this a problem as a matter of statutory law, it's also a problem as a matter of constitutional law because of several doctrines. One of the doctrines they cite to is the rule of lenity. Now, we've talked about the rule of lenity before, which basically says that if a particular statute or regulation, let's say, is ambiguous and it has criminal implications, which means you could go to prison and be a criminal, then if there's any ambiguity, which means there's more than one reasonable interpretation, the courts are supposed to, under the rule of lenity, presume and interpret that law in a way that is favorable to the law-abiding American, the citizen, and interpret it against the government. That's the notion of the rule of lenity. And one of the arguments being made here by the Second Amendment Foundation, the Defense Distributed Company, as well as, of course, Polymer 80, is to say that if there's any ambiguity here, and of course they first say there's no ambiguity, ATF is clearly wrong. So they say you're clearly wrong. But even if you assume there's some reasonable interpretation by the ATF, which there isn't, but let's assume for the sake of argument, arguendo, that there is, the rule of lenity would say that the ATF will lose this case. Then they go on and make a similar argument, which is known as the constitutional avoidance argument, which is very powerful. The way the constitutional avoidance argument essentially works this way, that if a court looking at a case where there's some question about what a statute means or what a regulation means or how it all works together, and there's a way of interpreting those particular items in a way that avoids a constitutional dispute, i.e. an issue as to the Constitution, then the courts should read the statute, read the regulation, read the dispute in such a way to avoid the fight over the meaning of the Constitution. And here, the brief is essentially saying that because you have due process concerns, meaning these definitions of what a frame or receiver is or what a firearm is so vague and fuzzy under the new regulation adopted in 2022 by the ATF, you now have created a due process problem because due process requires that you and I actually know what the law is, that we actually are able to discern what the law is. And the argument here is this 8-factor test of what an item in your grubby little hands could potentially become down the road with additional milling, grilling, manipulation, fabrication, whatever. There's no way to know. And that, again, causes a problem under the due process, because if you don't know whether or not what you're holding is legal or not legal or what it is, you have a due process problem, because again, if you don't know what the law is, if you're not able to discern what the law is, if you cannot discern as a citizen what is legal or illegal, then that's really unfair, and that violates the 5th and the 14th Amendment's due process clause, because again, if there's no way for you to know what the law is, that's just not fair, and that violates the notion of due process and fairness. The only other points I'd like to address, there's a lot of good points, I'll put a link to the brief down below. You can check it out. But the other 2 points that I thought were very good here is on page 20 of their brief. They do a very nice job saying that, look, Congress obviously decides what ATF and the Department of Justice can do or not do. It's the Congress that creates the statutory authority under which regulatory agencies can act, such as the ATF. And what's very interesting about the argument on page 20 is they talk about that when Congress wants to regulate a product, an item, they specifically talk about regulating the item. And they point out that in contrast, and this should not be conflated with the item, when Congress wants to regulate the manufacturing, creation of the fabrication of a product, right, they do that specifically as well. In other words, the point is that you have to be very clear when you're regulating an item versus when Congress is regulating through statute the creation or invention or fabrication or manufacturing of an item. See the difference? The item itself versus the creation of the item through manufacturing, fabrication, or whatever. Okay? And this is a good point to say that Congress, if Congress wants to regulate a frame or receiver in a firearm, as well as the making of a frame or receiver, they need to spell this out. And they really didn't do that. And therefore, the ATF trying to accomplish all this mishegoss, all this stuff, all these goals without a statutory authority is not appropriate. Okay? It's not being done according to Hoyle. And the last point I want to bring up about this brief that I thought was quite good is they really take the Department of Justice to task for saying, DOJ, when you're trying to say that criminals will evade the law if you don't do what we, the ATF, says or what we, the ATF, say should occur, then that is a problem, and you, Supreme Court, should bend over backwards to help the ATF and the ATF's interpretation out to protect us, the government, from law evaders. And this brief does an excellent job to say basically BS, I call BS, on what the ATF and the Department of Justice are doing, because what they're arguing in this brief is to say, look, our clients are complying with the law. Whatever the law is, our clients are complying, will comply to the extent we can discern the law. And complying with the law should not be conflated with or confused with the notion of evading the law. If the ATF thinks people are evading the law, that's really just complying with the law as it was given by Congress. And if ATF doesn't like it, the right recourse is not to start making stuff up on the fly and inventing things that don't exist. It's up to the ATF to go to the Department of Justice, to go to Milquetoast Moderate Merrick Garland. That's a joke, obviously. He's not Milquetoast. He's not moderate, despite the fact that's what he was sold as when he was up for a Supreme Court appointment to replace Justice Scalia. So I call him Milquetoast Moderate Merrick Garland, even though that's, of course, not true. Just want to make that clear. I know some of you ask about that in the comments. Again, if ATF can go to Milquetoast Moderate Merrick Garland and then talk to their Uber lords, their Uber bosses, Kamala Harris and Joe Biden, and say, hey, go lobby the Congress to change the law in some way to give us, the ATF, more power. Obviously, that's not doable because as a general matter, this Congress is not going to give the deep state the bureaucrats, the ATF, more authority to regulate constitutional rights such as the Second Amendment. So it's not going to go anywhere in Congress. And that's why the ATF tried to take things into their own hands in 2002 and hope is what they did. They could slide it by the courts. And obviously, given the fact the Supreme Court just granted cert in the Vanderstok case and is here in this case this fall, I'm guessing, obviously, it did not work to slide this law, these regulations, past the courts and past Americans. They were called out, and now they're before the Supreme Court, and they're going to have to explain to the Supreme Court how any of what they're doing is constitutional as well as consistent with the statutory authority given to them by the Congress. All right, folks, hope you learned a little bit something today about this powerful brief. I'll put a link to it down below if you want to read it all start to finish. Don't forget to follow me on X at @4boxofdiner. Make sure you subscribe and resubscribe. I know some of you get knocked off, so please resubscribe. Make sure you like this video, and we will see you again very soon, I hope, here at the 4 Boxes Diner.
Orders up. Table 2A.